So Lindsay has dedicated her practice around helping seriously injured individuals and their families who have been in motor vehicle accidents and wrongful death cases. As for associate lawyer, Nick Todorovic, Nick's practice is dedicated exclusively to plaintiffs' personal injury and wrongful death cases. McLeish Orlando is consistently ranked as one of the top 10 personal injury boutique law firms by Canadian Lawyer Magazine. They are also ranked law firm on Lexpert. Lexpert is a Canadian legal directory for leading practitioners and law firms. McLeish Orlando's ranking is based on extensive peer review process. McLeish Orlando is a recognized leader in wrongful death and personal injury law, exclusively representing individuals who have suffered serious personal injury or have lost a loved one through the negligence of others. So without further ado, please, Lindsay and Nick, take it away.
Thank you so much. And thank you everyone for being here to listen to our talk today. We tried to compile some questions that Nick and I hear a lot from our clients. And sometimes people are scared to kind of reach out and talk to the lawyers. They don't want to waste time. So we thought this would maybe be a good opportunity for us to speak about these commonly asked questions that we do have. If you do have questions, feel free to take a note of them. We're happy to discuss questions at the end. We know it's a lot of information, so save your questions and we'll do our best to help you out at the end. So without further ado, we'll get started. Okay, so this is a question that we get from clients from the very beginning when we first meet them to the middle to near the end. How long is this case going to take? So from the very beginning, it really depends on the jurisdiction that you're in. So if you're starting a lawsuit in Toronto, unfortunately, usually those cases take longer because our court system is fairly backlogged. What that means is that it's hard to get a trial date because there are so many trials happening. So it's harder to get the file moving as quickly as possible because you don't have an end date in sight. Typically, we would say cases usually take around 3 years, but if you're in Toronto, you have a complex matter, it might take longer. Another factor that would influence the length of how long your case would take is dependent upon when you reach out to a lawyer. So if you reach out to a lawyer a year and a half after your incident or your accident, obviously it's going to take longer from your date of loss because you haven't spoken with them until close to the 2-year statute of limitations that we generally have here in Ontario. So it's really dependent on a lot of factors. Obviously, complexity of cases, if there's additional parties that have to be added at a later date due to something called discoverability, that's your lawyer finding out new information later in the case, may make your case take longer. Perhaps you have a more complicated recovery where you've had an additional surgery and your lawyer might want to see a recovery, so that could influence the length of your case. And then generally speaking with pediatric or clients who are children, sometimes you have your experts say they want to see how the child progresses, and it could be several years until something's reached. That said, generally speaking, the human body takes about 18 months to heal. So in our firm, we wouldn't be necessarily looking to look at a resolution of a case until at least that point, unless something's very clear cut and we know that for sure the value of the case is known by that point. And from there on out, we do try to do our best to get things resolved as quickly and efficiently as possible, so long as we are aware of the complete damages. So Nick, do you have anything else to add to that?
Another reason why a case might be taking longer is the number of lawyers. Unfortunately, lawyers are very busy and coordinating their schedules can be a nightmare sometimes for our poor assistants. But it's usually the extra lawyer that gets added to the case, the longer it potentially might take. If you have 7 lawyers that are involved in a lawsuit, it could be very difficult to schedule something as simple as a mediation date amongst all of them.
So if you're wondering what stage your case is at, there's a couple questions that you should be asking your lawyer, which should kind of help you inform where you are at in the process. So one is, has a statement of claim be issued in my case? That is the document that starts the lawsuit. Another one would be, has an examination for discovery been scheduled in my case? The third question would be, has a mediation be scheduled in my case? The fourth one would be, has my matter been set down for trial? Do we have a pretrial conference date, and do we have a trial date? So your lawyer should be able to explain to you where you are within those parameters, and they should be able to explain to you when those are, the steps in between each other, and how long those steps they foresee them to take place, knowing that, as Nick said, that a lot of the times there's several parties involved, everyone's coordinating schedules. So I think we can go to the next question.
So, how much is my case worth? This comes up almost every time at the start, and like Lindsay said, at every point throughout litigation. The client wants to know a ballpark of what their case is worth. From our perspective, there are really three things that need to be considered: is time, expert opinion, and documents. These are three major things that need to be considered before a lawyer can even ballpark where how much your case is worth. For time, as Lindsay said, it takes the body approximately 18 months to heal. In order to get an expert opinion on prognosis and diagnosis, you really have to wait until that period of time, until there is a plateau or a stability of the injury for a doctor to feel comfortable to provide those opinions. And then the value of the case is based on the opinions of the experts. So a lawyer should be obtaining expert opinions on diagnosis, prognosis, in order to help you gauge, as a lawyer, us, what the damages could be worth. And in any lawsuit, there are three major heads of damages. There's pain and suffering, there's loss of income and earning capacity, and then there's future care of what the individual might need into their future, which could be attendant care, housekeeping, physiotherapy, psychology, occupational therapy, anything like that. And the expert opinions really come to help quantify loss of income and earning capacity and future care. And they provide treatment recommendations as well as prognosis going into the future. So that's another key aspect of it. And in order for those experts to be able to provide those opinions, they're first going to be examining the individual, as well as going through all the documents that have been produced. And there's generally a wealth of documents that are given to an expert that they can go through, such as hospital records, ambulance call report, the motor vehicle accident report, if there is one, the accident benefits file, family doctor, occupational therapy, physiotherapy, anything, anywhere that the individual has gone, that expert is going to be going through all those records to formulate their opinion. And then once all the experts are put together, that gets sent to a future care expert that will then be able to compile all the recommendations and create a treatment profile of what their future will look like. Once that's done, that should go to an accountant to be able to quantify all of that, as well as your income loss, if there is one in that particular case. Once that's all done, that will give a much better and accurate picture of what your case is worth, and it's generally a range. But that being said, there's a lot of other factors that need to be considered, such as liability in the case, contributory negligence of the plaintiff, if that exists, that causation. There are a lot of factors that come into play in terms of being able to properly quantify what a case is worth. And at the end of the day, as lawyers, we can only provide our recommendation as to what a reasonable settlement will be based on all of these factors. We can never guarantee what a case will be worth going to trial, especially if there is a jury, because a jury will only be given questions at the end of a trial in terms of what they feel the true value of the case may be on certain heads of damage. And it's really up to them to determine that. And at the end of the day, the only way to determine what the true value of a case is to go to trial. And when we're at a mediation stage or a pretrial stage, it's really up to the plaintiff lawyers and defense lawyers to determine what they feel is the true value of the case at that time. And like I said, there's so many factors that come into it. When you're thinking of a wrongful death claim, it is a little bit easier, only given the fact that generally the damages only arise on what's called a loss of care, guidance, and companionship. And those damages are generally set by case law throughout the years. And it's based on the relationship with the lost loved one. And in a situation like that, it's a little bit easier to be able to quantify what a case is if it's really just left to that head of damage.
Yeah, and I think kind of what Nick said, there's a certain point of time that everyone would wait just so that you can get a proper prognosis. And when you come to points where a settlement offer might be made to you as the client, typically in our office, we would provide our clients with what we feel an appropriate, reasonable range of settlement might be. Could be at the upper end, could be at the lower end. And then there's a decision that should be made at that point as to do we proceed or do we not proceed. So we should go on to the next question.
Sure.
Okay. What is an examination for discovery? So you're kind of thrown in this terrible legal process and your lawyer's telling you have to go to an examination for discovery, and it's the one time as a plaintiff you really are on the spot and have to perform, except for if you have to go to a trial. So an examination for discovery is the opportunity for the lawyer for the insurance company to ask you questions about your case. I like to kind of call it a fact-finding mission. And that's because this insurance lawyer's had the opportunity to read all your clinical notes and records. They've read the police file. If there's medical briefs, they're going to read the medical briefs. So they get to kind of know you on paper, but they have no idea how this has affected you personally. And they have no idea how this is going to look to a jury. So if you're a kind person who's credible, who's honest, who's very likable, an insurance lawyer is likely going to report back to the insurance adjuster that this is a person a jury's probably going to like. It's going to be a hidden persuader in the trial, and potentially they should look at settling it. Rather, if you're a dishonest person who exaggerates, who a jury might not like, it may affect their opinion of the case. So your lawyer will likely have a discovery prep with you. The discovery will focus on all the claims that you have made against the insurance company, or typically the other driver who's represented by this insurance company. So it will usually go over how this happened. And like Nick said, they might ask you questions mostly related to the police file, but just to get your sense of what happened, to see if there's any way that you were partially responsible for the collision. They're going to ask you about your injuries, how they were at the time, how they've progressed, if doctors have told you what your future might look like. They'll ask you about your loss of income if you've sustained one and issued a claim for that purpose. And they're going to ask you about kind of like your past education, as well as if you've made it back to work, how is work looking now? And are there any changes? Have your aspirations changed? And unfortunately, if you're not working, haven't been able to get back to work, they're probably going to ask you about what your intentions were for the future. And if you wanted to work for a longer period of time, if you had plans to retire early. They'll ask you about your house and who did the inside and outside household chores, because you've likely made a claim for loss of household and handyman capacity. And of course, there's all the things that you used to do for fun. That's your pain and suffering and loss of enjoyment of life claim. So if things have changed for you, if you're not hosting family dinners, if you're not traveling, if you're not doing sports, or if those activities have been affected such that you're doing them less, or alternatively, they're just not as fun as they used to be, the insurance lawyer has to know about that. And that's because they have to understand that the case they're going to meet at trial. So if we present evidence of trial of all these things that our clients are struggling with, they need to get to know about that before, and that's the main purpose of a discovery. So our role as lawyers at the discovery are strictly to make sure that only legally correct questions are being asked of the plaintiff. So we would interject if we felt a question was not legally appropriate, and that's all we can really do during the discovery process. It's an examination that's under oath, so you are required to tell the truth. And a lot of people get very nervous because there's a lot of questions. If you feel like you answered a question incorrectly during the discovery, you should tell your lawyer, because your lawyer is obligated to tell the other side that you made a mistake or you forgot to tell them about a certain piece of information you were asked about, and your evidence will be corrected. So that's the main purpose for it as a plaintiff. We as plaintiff lawyers get to also examine the defendants, the people that we're suing, to see what happened and to prove that they are in fact at fault. In cases like a products liability case, you might have several people involved. There might be manufacturer, designers, the people that sold the product. So those discoveries can take a great deal of time. Or in a simple motor vehicle accident case, you might just be examining the driver of the vehicle as well as the owner of the vehicle, just to see what they have to say so they can describe the force of the impact, why this happened, any sort of information they have about the aftermath, any information about witnesses, things like that. So that's the main purpose of an examination for discovery. Most, if not all, of our clients get quite emotional during this process. And I think what's really important to remember is that, unfortunately, this is something we as plaintiffs' counsel are used to, and so are the defense lawyers. So don't feel bad if you get upset. You can take breaks at any point in time that you want. I'd like to think that our bar group of lawyers we work with is quite what we call collegial and understanding and empathetic. So no one's there to try to make it a terrible day for you. But they do need to ask the questions because that is their job. But you can always take breaks and also talk to your lawyer before, just to make sure you kind of know the types of questions you might be asked. Do you have anything else for that one?
Just as a witness, obviously, it's a long process. It's basically a full day for you, at least 3 to 5 hours. Just remember, that is not a time for you to make a case for yourself. That's not a time for you to make it to make your arguments. That job is for us. You're just there to answer the questions that are asked of you and nothing more. That process is not meant to help you. Just like when we ask the defendant questions, that process is not meant to help the defendant. Each side is trying to get helpful admissions to help their case and weaken the other side's case. Okay?
All right, let's go to the next one.
Now, what does it mean when the insurer denies a benefit? Now, this is more in the accident benefits realm rather than the lawsuit tort realm. For the accident benefits, there's obviously a lot of forms that are filled out depending on what you need and the level of your injury in terms of what category you're put into, whether non-catastrophic or catastrophic. And these forms then allow you to obtain certain benefits like medical and rehabilitation benefits, attendant care benefits, income replacement benefits, or non-earner benefits. There's a lot of them. In certain situations, the insurer may ask that you attend insurer examinations to determine if you should be receiving a specific benefit or treatment. And at the end of it, they will have a report generated that gives an opinion on whether, for instance, a med rehab benefit is reasonable and necessary. And if their expert says no, then the insurer will deny that benefit and send you a letter in that regard denying that. At that stage, it's up to the lawyer to determine whether that is something that needs to be disputed, and they'll take a look at whether it's been incurred and whether you do need that treatment plan. After every denial, there is a 2-year limitation in terms of being able to dispute that, and disputing it is done through the License Appeal Tribunal, or the LATT. Lindsay's going to talk about that in the next slide. So that's with respect to med rehab. There's obviously attended care as well. You have Form 1s that determine the quantum or how much per month of attendant care you need. And then it's really up to whether a PSW is coming in or someone else is coming in to incur that attendant care benefit. Also, that can be scrutinized by an insurance examination by an occupational therapist. The insurance company will have their own Form 1, and then there could be a dispute as to how much that attendant care is valued at, or whether you even are entitled to attendant care based on your level of function. And again, that would be disputed in the LATT. Same with income replacement benefits. After the 2-year mark, the test changes and becomes a little more difficult. And usually an insurance company will want to examine you in terms of your function to determine if you can return to some form of employment. That could be vocational assessments or functional ability assessments. But that generally is what happens around the 2-year mark, unless it's blatantly obvious that there is no way that you can return to any form of employment. So it really comes in terms of disputing a benefit. It's more of a strategic perspective from the lawyer's point of view as to when a dispute should happen. In certain situations, it may be that they want denials to run at the same time so they can dispute everything all at once, because the insurance company may deny things throughout the whole process from when you first submitted your application for accident benefits. Same thing happens with catastrophic impairment determination. An OCF 19 will be filed, which will and sent to the insurance company, which will then trigger them to do insurance examinations to determine if you're catastrophically impaired or not. And again, there's a 2-year limitation on that to determine if to dispute that with the LATT. So denial of a benefit doesn't automatically trigger a dispute. It's really up to the lawyer to determine if that's something that should be disputed based on if it's been incurred or if you really need it. Not all benefits that are denied will be disputed by your lawyer. It's really up to how they determine what is important for your case.
Okay. We'll go to the next one. Okay, so with that in mind, I'm just going to talk about what this LATT is, the License Appeal Tribunal. So if you've had a benefit denied, you've likely heard your lawyer speak about, well, we're going to bring a LATT application. In accident benefits, you cannot sue for denied benefits. You have to go through the License Appeal Tribunal to see if you are in fact correct as to if you should have that benefit instated or not. So it's almost like a form of a court in a way, because you would be proceeding to an arbitration, which has an adjudicator in the place of a judge to determine if the benefit's correctly denied or if we are correct that you should have the benefit. So it's really just, it's an office building. You would go there, you would sit almost like in a boardroom situation, and there would be witnesses that give evidence. So in the case of whether you should have physiotherapy, it would probably be your physiotherapist that submitted the OCF 18. And if the insurance company had an insurance examiner look at it and say, no, this benefit should be denied, they would be the witness for them. We would probably call you, the applicant, as a witness just to get evidence about your needs, how this has helped, things you've worked on. And the insurance lawyer would ask you questions as a witness there. So it's like a little mini hearing, if you will. These disputes happen often. A lot of the times we proceed to something called a case conference, which is a mandatory step before you get to an arbitration. At that point in time, oftentimes that matter could be resolved. It might just be for the issue and dispute. So in that example, just the form about your physiotherapy. Or the insurance adjuster or insurance lawyer might suggest that they settle the accident benefit file on a full and final basis. So what that means is that the insurance company wants to give you your money for you to manage for your own treatment needs. And a negotiation is brought between the plaintiff's lawyer, the applicant's lawyer, yourself, and the insurance lawyer and the adjuster to see if a reasonable amount of money can be brought forward to resolve the case, so they don't have to continue to adjudicate your benefits and like dollop them out to you. So oftentimes it settles there. If it doesn't, it might proceed to a hearing in person. Right now, everything, to my understanding, still is through virtual hearings or written hearings. That's always been the case with the LATT, that you can have hearings in writing. It's not just because of COVID. I'm not sure if they've gone back to in-person hearings. Do you know?
No, I don't think they have.
So right now, everything's being done virtually, which is okay. It could be worse. And if not, if we're really insistent upon an in-person hearing with an adjudicator in that kind of boardroom setting, like a mini trial, if you will, it would be until the precautions with COVID have been lifted. So that's what the LATT is. It's separate and apart from your negligence claim for damages or your lawsuit against another driver that may have hit you. It's just to do with your attendant or your medical benefits through your accident benefit provider, okay?
Okay. After examinations for discovery, the next major step in most cases is scheduling a mediation to see if the case can be settled in an out-of-court process. The parties come together at a mediation with a neutral mediator who will see if a reasonable resolution can be reached at that time. In Toronto, Windsor, and Ottawa, it's mandatory. Specifically in Toronto, you cannot proceed to the next step of your tort case without mediating. And during the mediation, it's a confidential process. The mediator will likely say things like, it's out of court. This is the party's opportunity to see if they can get this resolved. And then they usually say something along the lines of, if it doesn't get resolved today, then it's going to be in the hands of 6 jurors that are going to be deciding your fate, and you really have no more control. And today, on mediation, this is where you have control. Well, that is technically true, but in practice, it's not the end-all be-all if you can't settle at mediation. The parties coming to mediation are obviously, they've prepared the case for the most part, and plaintiffs should have all their reports. They should have their case built up for trial, essentially at mediation. And that's where they present their entire case, right then and there, the value of the case. And that's where the parties try to hash out any issues that they may have with liability, if liability is a big problem, and also if damages are a big problem. Sometimes mediations, they don't settle, but that doesn't mean that it was, although it's technically failed, it doesn't mean that it was a failed opportunity. In most cases, the plaintiffs presenting their case and what they feel the case is worth to the adjuster that is sitting there at mediation, or by virtual mediation now during this COVID age, it allows the plaintiff to almost put the insurance company on notice of, this is how I see the case, this is how big the case, this is how the value of the case, this is how I view the issues. And in some cases, that's the first time that the adjuster gets to hear that. And it may cause them to have to reevaluate how they see the case, and they may have to seek further instructions. And even though it failed for that day, it doesn't mean that it was all for nothing. In some cases, an adjuster will show up to mediation with a certain amount of authority. Although there may be $1 million in policy limits, that doesn't mean they're showing up with $1 million. They may only have authority for $250,000, even though your lawyer, or you may see this case as something over $500,000. Well, that means that although the adjuster only has that amount of money, they may have to go back to the committee or whatever the case may be within that insurance company to seek further authority. And even if it doesn't settle at mediation, that doesn't mean the lawyers can't pick up the phone and see if they can't resolve their differences after the fact. And also, there's a pretrial that comes after a mediation where it's in front of a judge. And that's where a judge will also get involved and see what they can do. And Lindsay's going to be talking about that in the next question.
I mean, I think the best way to look at a mediation is to understand that it's a step in the process, and over 50% of mediations do fail, but I think the statistics are somewhere around 97% of cases settle before going to trial. So there is this time period in between mediation and trial where files do settle, and it's an important step where plaintiff's counsel gets to present their case, like Nick said, but you might narrow some issues between counsel. Say contributory negligence is an issue. Perhaps you land on a percentage figure that you agree, okay, we're going to say the plaintiff's 15% at fault. Defense had originally wanted 30%. Now we're settled at 15% so that negotiations can kind of work together. A lot of the times we have very experienced mediators working with us, and 6, 8, 12 months later, they might follow up and say, has anything changed? Are we looking to reinitiate settlement negotiations? And perhaps defense counsels have the opportunity to have their adjusters look at different reports. Things may have changed on their end, and sometimes cases get settled that way. But this kind of brings me to my next point, and if you can just
Sorry to interrupt, Lindsay. We actually, we've noticed that the slides, they're not changing.
Well, they're not that big a deal. It's okay. They're just title slides.
Okay.
They just have the question on them. So as we read them out, that's basically all there is on the slides.
Okay.
Okay, so the last point we're going to say was, what is a pretrial conference and what is its purpose? So like what Nick was talking about, the next step after a mediation is typically a pretrial conference. This is when lawyers are sitting with a judge. The clients are typically in a hallway, and the judge has the opportunity to review the case and kind of look at each lawyer, point out the strengths and weaknesses to both, understand if there's offers passed back and forth, and really try to narrow down, is this case something that can be resolved before a trial? And speak with both lawyers. Sometimes they have clients come in to discuss certain issues with them. This happens more specifically with more sophisticated clients, or clients the judge would like to get a understanding of for himself or herself. So we do see that. And then unfortunately, if the parties are just too far apart, that time can be used to help prepare for the trial and get narrows issued, have certain documents prepared and reviewed to make sure that the trial process is done as efficiently as possible. So doesn't mean you're going straight to trial if you don't settle at mediation. There still is this pretrial step. There's still a ton of time between mediation and pretrial, and unfortunately between pretrial and trial. So doesn't mean you're going straight to trial. But that being said, I would say it's important to make sure that your lawyer is preparing your case as if it is going to trial to get the maximum amount of potential settlement dollars out of the insurance company. So don't be afraid if you're kind of getting to those stages, and I'm sure everyone would be in great hands if a trial does have to happen. So I'm just looking at the time now. It's 3:51, and I think we have till 4. So if anyone does have any questions, I'm not sure how this process works at this point, but we're happy to kind of spend a couple minutes now if there are questions.
Yes, so I have a question here. It's for the first question that you guys covered, for how long should a case take? And someone wanted to know if you could please repeat those parameters. Yeah.
Sure. So I think what we were saying is that really every case varies, and it really depends on the jurisdiction. It depends when the lawsuit was started. It depends if new issues have arisen because of, if there's new parties that need to be added, if there's a decline in, You're welcome, Monica. Sorry, we're just seeing these little notes now on the side here. So yeah, so it really depends on every case. Sometimes someone may have to have alteration or different surgical procedures later in the case, and someone might want to see how it heals. If you're a child, you might have to see how they progress through school a little bit further. It really depends. But if you do want to get a sense of where you are in your case, you should ask your lawyer, has a statement of claim been issued? Is a discovery booked? Is there a mediation, and are we going to be scheduling one? Has the matter been set down for trial? Do we have a trial date? Do we have a pretrial conference date? So those are typically the steps of a lawsuit, and it should kind of inform you where you're at, and then your lawyer should be able to kind of reasonably give you ranges between those little mini steps. All right. Is there any other questions?
Yeah, there's that one down there. With COVID, many attendant care services have been canceled. How will this impact my case? And that's from Nafisa.
Okay, that's great, Nafisa. It really depends. I know it's really been tough on a lot of plaintiffs to get the services and care that they need. We're in kind of a new world too, where we don't know the complete impacts of this. We just know that our clients do need help still. And I think a lot of attendant care providers are kind of coming up with some creative solutions to try to help facilitate care. But for us to kind of know for certain how this will go in the future, I don't think either of us can say. I do think what would be important is if you're noticing that there's certain areas that you're really struggling with, it would be important to kind of take note of that and let your lawyer know, so that your lawyer can let your insurance company know. So whether that's, you used to have a personal support worker coming in to help you out with meals, and now you're kind of limited to simple egg or peanut butter sandwiches because you're really struggling cooking on your own. Those would be important things to let your lawyer know about.
Yeah, and also your treatment team. If you have an occupational therapist, make sure that you are telling them all of the issues that you're having, because you're lacking in a PSW or someone to be there as often as possible, as often as they normally would be, because that occupational therapist is the one that's creating progress reports and noting everything. So just make sure that you're vocal about all of the difficulties that you're having without that service, or without other services that may be affected because of COVID. The insurance company, I think both sides have recognized the struggle that is going on right now, and an insurance company really has no excuse to hold that against you for not having that treatment available to you.
So we just got another question saying, is it typical to skip mediation because defense lawyer doesn't want to have one, then go to a pretrial, at which time the judge advises to go back to mediation and not trial? So this is a good question, and this kind of relates back to how every case can be different. We oftentimes will file a trial record with which gives us a pretrial conference date without doing a mediation if we're outside of those jurisdictions. So as long as you're not in Ottawa, Toronto, or Windsor, you can proceed straight to pretrial, and this is a way of making sure your case is moving efficiently. Why the defense may not want to do so, I'm not sure. Every case is different, like we said, but that step does happen where you go straight to pretrial, and oftentimes it's on our own accord. Sometimes it's on the defense lawyer's accord. Have we been told to go back to mediate? I personally haven't. I don't know if you have.
I'll say this, that in every judge's mandate is to make sure that the parties are encouraged to work together to settle the case. And generally that's done through mediation. And a judge at pretrial, one of the first questions they'll ask is generally, has this mediated, especially if it's out of a jurisdiction where mediation is mandatory. So they'll want to know if the parties have actually gone to attempt to settle this matter. And if they haven't, well, it may be a situation where they ask them to mediate before trial.
Yeah, and I think what's really important through this whole process is to remember that your lawyer is there for you, and if you have a question like that, like you should feel like you should give them a call and ask them to walk you through why that happened. I'm sure they would be happy to kind of talk to you about the specifics of your case, but that's a great question. I'm sure your lawyer would be happy to answer.
And in some cases, as Lindsay said, the judge will be there to help resolve any issues for trial, but depending on the type of judge, because the judges come from all different backgrounds, you may have a judge that is experienced in personal injury and may take the reins on trying to resolve this case if it's possible.
Or in some cases, in smaller jurisdictions, for instance, I've had some people say, I'm a family law judge, or that's my experience. I don't have as much experience as others, so perhaps that was the case. It's really, up to your lawyer to kind of explain why that happened, and I wouldn't be worried about it.
Okay, I have another question here in the Q&A box. They said, thanks for the great presentation. Attendant care was denied when client non-CAT and are not willing to approve a Form 1 assessment now that they are CAT. How can this be dealt with?
I would call your lawyer. That's, thank you for liking our presentation. I'm sorry, I was just we're reading off the screen. Denied when you were not CAT and are willing to approve a Form 1 now. Yeah, I think that's probably something you should give your lawyer a call about, and they can walk you through what's going on with your particular case, to explain to you why that's happened, and if they suggest any steps going forward, and try to get the lay of the land that way. That's a perfectly fair question to give them a call about.
Exactly. The timing of when a Form 1 assessment is going to take place, there could be reasons for why they're not allowing that. It's very fact specific for that particular case.
Nafisa, no, the judge is not always the same. There's hundreds of judges. So there's tons of them.
And just so you know, a pretrial judge will never be the trial judge.
Yeah. Is there any other questions?
Does anyone have any more questions or comments?
Well, if not, well, thank you everyone for taking the time to listen to us. We hope it was somewhat helpful for you. We wish you the best of luck with your lawsuit. We know it's sometimes a frustrating process, but I do encourage you to always give your lawyer a call should you have any questions. I'm sure they're happy to kind of help answer the questions, because we do understand it's a very overwhelming process.
Oh, there's just one quick question that just came in just now. Is it typical to not have any idea of the worth of a case after 5 years?
Like I said, to be able to value a case, you need a variety of information. You need all the medical documents. You need expert opinions. You need someone to quantify the future care. You need someone to quantify a loss of income if it's there. So unless you have all of that information as a lawyer, it's really, you're basically crystal balling what a value of a case is. And even when you do have those expert opinions, that can only provide you with a range of what the value of the case is worth. And again, if there are liability issues, that will also impact the value of the case. If the plaintiff is held to be 50% responsible, then you're going to lose half of the value of that file. Again, there's surveillance that if there are, sorry, what is?
Yeah, so defense counsel not responding and dragging their feet does happen. That is a thing that unfortunately happens.
Yeah, it's the plaintiff. Basically, plaintiff's counsel is the one that leads the dance. And if defense counsel is lagging behind, which they normally do, the plaintiff's lawyer has to take the reins and push things forward. If it has to do with waiting on offers and whatnot, I mean, it's really up to the lawyer to decide what the next step is, and making sure that your case moves forward as fast as possible to make sure that this gets resolved for the clients, because this process is a very big grind, and it's not a fun process, and it's up to the lawyer to make sure that they can get the clients through it as fast as possible.
Yeah, so just make sure you ask your lawyer, do we have a diagnosis? Do we have a prognosis? Do we have all the reports that we need? If we don't have the reports that we need, when will those reports be coming, or why haven't they happened already? And like, if you ask them those questions, sorry, I don't know your name here, they should be able to kind of give you a better sense there. Some things that sometimes come up late in the game is a witness statement might come up that's not favorable to your case. That could change the value. They may conduct surveillance where that might affect the value of the case. There's so many different factors, but I sense the frustration that you are experiencing. And whenever that happens, I really encourage you to kind of call your lawyer, go over your frustrations. It's okay to ask these questions, and don't feel like you're wasting anyone's time.
And in terms of the length of a case, generally speaking, the average case will be approximately 4 to 5 years.
Which
So
we aim to be better, but
if you feel that it's been dragging out, just understand you're not alone. This process takes a long time, and that's only because of having to wait for your injuries to stabilize in order to get an expert opinion, coordinating lawyers, that type of thing. It does take many years to be able to come to a resolution.
Sorry, we're just talking to one person on this webinar, which is totally fine. I know it is frustrating, especially like if you've gone through all the steps. So like I said, make sure a claim's issued, make sure you have a discovery booked, make sure your matter's being set down for trial. From our perspective, in a perfect world, a perfect case where we meet the client within a first week, and it's a case with straightforward injuries, we would typically try to have examinations for discoveries 18 months after the accident, with a mediation and the matter set down for trial 24 months after the accident. From there on out, like I said, if you're in Toronto, you're going to be waiting years for a pretrial conference, unfortunately. So yeah, so that's pretty much what we can really say on that front. But thank you again for everyone that is taking the time to listen to us, and we hope you're all staying well during COVID and enjoying some of the summer weather.
Thank you. Take care.
Yes, thank you, Nick and Lindsay, for presenting today. It was very informative. So on behalf of BIST, we thank you so much, and as well PIA Law for your continuous support. I just wanted to let everyone know that this webinar is recorded, and you can find it on our website eventually at www.bist.ca/webinars. It will be on our YouTube channel as well. We could email it to you directly if requested. Also, if you'd like to contribute to any upcoming webinar topics, please feel free to email us at info@bist.ca. We want to hear from you. We want to know what's important to you and what you'd like to talk about and hear about. As well, we have our last session for the Summer PIA Webinar Series, August 25th at 3 p.m. It's going to be another really great informative session, brain injury, the pandemic inside a pandemic. So please join us for that, and the registration is on our site at www.bis.ca/PIA, and you can sign up there. So again, yes, thank you for everyone for tuning in today, and we hope you really enjoyed.
Great. Bye
Thank
now.
you.